Now we're going to move on to a presentation by Farhana Hamid-Butt. Farhana is a student, a PhD student at Cambridge, but she was telling me about this case about crypto assets, and which I hadn't got around to reading at that stage, and it sounded very fascinating, and I thought it'd be wonderful for everyone to hear about it. Some of you, I'm sure many of you now have heard about this, even I have now, and so I look forward very much to what she's going to say. If you can have the hard task, Farhana, of dealing with the lawyer in 10 minutes, that's great. Thank you. Over to you.
Thank you, Louise. Thank you very much. Can I just check that you can see and hear me clearly, please? Can you see me and hear me clearly?
Yep, perfect.
Oh,
Yes.
fabulous. So my presentation's called Tracking Tether and Trustlessness, the Implications of Dallara and Persons Unknown. I'll be discussing the High Court judgment in the Dallara case, which I think is arguably one of the most significant decisions of the English courts in relation to crypto assets as in the year 2024. Can't quite believe it's 2025, but there you are. I shall commence by outlining the key facts of the case. I'll then proceed to summarising the judgment. The judgment was handed down by Richard Farnhill, sitting as a deputy judge of the Chancery Division. And finally, I'll share my perspective on why this decision is instrumental to the future trajectory of the crypto asset realm. So to start off with the facts of the case are not too dissimilar to many of the cases, crypto asset related cases that have come before the English courts. The claimant, Mr. Dallara, was fraudulently deceived into transferring approximately £2.5 million worth of Tether to an online platform called TD Finance, which he mistakenly believed was associated with the reputable brokerage firm TD Ameritrade. The claimant's funds were then moved through various blockchain wallets in a series of transactions. They were intermingled with other funds before being withdrawn by the seventh defendants as fiat currency. The claimant issued proceedings against persons unknown, as well as other crypto exchanges with which the seventh defendants were alleged to have had accounts, and from which it was alleged that the crypto assets were transferred from the blockchain into the traditional banking system. A term for that is often off-ramping. So the trial was concerned with the claimant's assertion that a portion of his tether had ended up in the wallet of a Thai customer of BitCub, which is a crypto exchange based in Thailand. A significant factual issue at trial was whether the claimant could establish that his funds had in fact moved into the relevant BitCub wallet. The judgment concerned whether the claimant could make out a constructive trust claim, or alternatively bring a claim in unjust enrichment, and in turn follow and trace the crypto assets into the BitCub wallet. In turn, BitCub relied on various defences, including change of position, ministerial receipt, and that it was a bona fide purchaser for value without notice. The claimant disputed the availability of these defences on the basis that BitCub had not behaved in a commercially acceptable manner, since it had notice of suspicious account activity. Turning to the judgment itself, the trial judge dismissed all of the claimant's claims because the claimant failed to factually illustrate that any of his tether or its traceable substitutes had been received by BitCub. In order to demonstrate that BitCub was enriched with the claimant's crypto assets, it was not enough simply to show that the movements or hops from wallet to wallet were sham transactions. It was necessary for the claimant to have illustrated why the sham transactions contained his crypto assets. and not those of other victims. The judge found that the claimant's blockchain analytics expert had failed to explain the basis for his methodology, which meant that his evidence could not be relied upon. As the claimant failed to establish the link between his funds and the Bitcoin wallet, the Bitcoin wallet, his claims premised upon constructive trust and unjust enrichment failed. Furthermore, the funds that the claimant alleged to have been traced to BitCub had already been transferred away, leaving no asset over which a constructive trust could be based. This matter might not have been fatal had the claimant pleaded a claim in knowing receipt liability, but he did not do so. So, albeit obiter, the judgment raises very interesting questions in relation to crypto assets. In the interest of time, I'm only going to focus on 3 of these aspects, and they relate to the property law aspects primarily. First of all, Delaware is the first non-interim authority on the property status of crypto assets. We've seen many cases, AAN persons unknown being the first example, well, one of the first examples, in which the courts in interlocutory hearings have said that crypto assets are capable of forming objects or constituting objects of property. But this was a non-interim hearing, it was a full trial. Despite the fact that it wasn't a matter contested at trial by the parties, the judge commenced by considering whether Tether can constitute crypto assets under English law, since such a determination would allow him to decide whether the claimant's crypto assets could be traced or followed. To this end, the judge addressed in some detail academic criticisms, arguing that crypto assets ought not to be treated as proprietary. And nevertheless, he concluded, as I'm sure many of us will be pleased to hear, that Tether is capable of attracting property rights under English law. It is neither a shows in action, nor is it a shows in possession, but instead, it is a distinct form of property which is capable of being traced and held on trust. The judgment predates, interestingly, the introduction of the Digital Assets Bill, and the bill too cements this position. Turning to my second point, the judgment makes it clear that the next legal challenge in relation to crypto assets will be to conduct the indicia of the third category of property rights and demark its parameters. I think that the discussion pertaining to following neatly underscores this point. So following entails tracking an asset in which a claimant has an interest in, a proprietary interest in, as it moves from hand to hand. Fundamentally, a claimant is unable to follow an asset if that asset has ceased to exist. In relation to the traditional categories of property, that is to say, things in action and things in possession, so I'll take things in action first. Things in action, such as a bank account balance, cannot be followed through mixtures because once mixed, the asset ceases to be identifiable. In contrast, a thing in possession, which is traditionally held to be tangible, can be followed so long as it remains identifiable. The judge rejected the idea that transfers of tether result in the destruction of one asset and the immediate creation of another. Instead, he suggested that tether persists through transfers, and I found this aspect to be quite interesting because in much of the literature, also included in the computer science literature, it's often said that when Bitcoin, for example, is transferred, one set of data is destroyed and a new comes into life. So this persistent assets view was quite interesting. So accordingly, the judge held because tether persists through transfers, it would be possible to follow, not just trace tether, even if it is commingled within mixed funds. This was especially so since USDT or tether remained identifiable when mixed due to internal records maintained by Tether Limited. Although I must say these records were not presented to the court, which impacted the claim. It remains unclear, having said all of this, whether it will be possible to follow crypto assets other than Tether, since the Tether white paper was instrumental in allowing the judge to conclude that it was possible to follow Tether as it moved from wallet to wallet. My third point relates to tracing. In relation to tracing, the court signaled that the methodologies available to a claimant seeking to trace misappropriated crypto assets are not limited to, amongst others, the method of first in, first out. But in the case of fraud, the claimant should be allowed to rely on any other method, providing that it treats all claimants and potential claimants comparably and is properly evidenced. However, this aspect of the judgment does sit in tension with two other first instance decisions. Those decisions are the decision in Charity Commission and Frangi and SFO and Hotel Portfolio. The latter two cases suggest that the default starting point should always be the first in, first out rule. It thus remains to be seen whether the flexible approach proposed in Delaware will be upheld in the future. And to conclude, I think the judgment crucially illustrates the judicial willingness to adopt a creative and non-rigid approach when contending with crypto assets, which is a hallmark of the English common law. Thanks.
Thank you very much indeed.